know, in the conversation I had with Robin Hayes,
Yeah.
he asked me to resign. I told him why I couldn't. From an ethical standpoint, as a judge, you just can't leave that kind of work on the table and make everybody else do your work. And so I need the extra time to wrap up. But I told him I was perfectly interested in serving out my term if a way could be achieved to distinguish between how appellate judges retire and how the trial judge retires. And he said they wouldn't do that. And then at that point I realized it wasn't that they wanted to keep a Republican in the seat, because they're perfectly capable of passing any law they want to extend the term. It's they had a particular Republican that they wanted to put in the seat, and that just wasn't me. And that's what I told him, and he wouldn't answer the question. But
is that right, though? My understanding is that they wanted to get rid of, they wanted they didn't want any, didn't they want to shrink the size of the court broadly?
Well, that was the way he said we'll approach this problem in a different way, and I think that's the different way that they approached the problem.
Was by shrinking the court?
By shrinking the court. When I retired, the court would go down in size. And when that bill was introduced, I assisted getting the signature on a letter to all members of the legislature signed by all the ex-chief justices about what a bad idea that bill was, not only for the shrinking of the court, but the transferring of some of the court's work, the termination of parental rights cases, which involve these kids in legal limbo because they're in bad home situations, can't be adopted or even have a permanent foster family until their case is settled. And we have an expedited process for settling those cases so that these kids can move on with their life. And they transferred those cases to the Supreme Court beginning in 2021. And we wrote a letter to everybody. That didn't work. So the weekend before the veto override would take place on that legislation, I was contacted by former Chief Justice Burley Mitchell, and he said, "You are on the court. You know what this is going to do to the court's process better than anybody else. So why don't you do the right thing and let the governor appoint and keep the court at 15? And I talked to my wife, I talked to my former law partner, and searched my conscience about what it would feel like to know that you had allowed the court to be deliberately impaired. And I know what that meant because I've been there, and I know how administratively unworkable a court that sits in panels of 3 will be when it goes down to 14 or to 13. But it'll never reach 12 because you can look at the biographies of everybody's bio that's on the court website and see their ages, see when people are going to retire. It'll never get to 12 in the foreseeable future. So the court will be impaired for a substantial period of time if this legislation stays on the books. So,
what was the point of it, as far as you understand? Why would they want that, a smaller appellate court then?
I think that they want it to be smaller until they can get Cooper out of office, and then they'll expand it back to 15 and give the Republican governor an appointment so they will say, we were wrong. The court is busy. Here, Governor, we'll expand the court to 15, and you're at 14 or 13, and now you've got 2 appointments to the Court of Appeals. That's my take on it.
Blatant power grab.
Yes. Similar to the amendments that they have on the proposed, where that any board or commission would be filled by the legislature and not by the governor, or that judicial vacancies would be filled by the legislature and not by the governor.
But why and what it means?
Well, I think a great many of the members of the legislature believe that judges act and react the same way they do. They take a vote in caucus on a policy issue, and then that policy is going to be pursued. They don't understand that judges are not legislators, and that they adjudicate on cases that are put in front of them based on the application of the law to the facts of the particular case. And so we approach our decision making in a completely different fashion, and they just don't grasp that. In fact, some legislators were at a seminar, separation of powers, and some legislator made the remark that appeared in the newspaper that I read that said, Well, I don't understand why the judges get to pass on the constitutionality of our laws because we know them better than they do. We wrote them. And it's like Civics 101 hasn't even been grasped by this group, and that's why they're treating the judges that way, that politics comes second to being a judge and being involved in the justice system and making sure that the justice system is functioning appropriately.
That's the way it should work, though.
Well,
right?
that depends on who goes into the job of being a judge. And you would hope that most people have the integrity to do it the right way. Now, there isn't a state in the Union in which politics isn't involved in getting to the bench. In South Carolina and Virginia, where the legislature does pick the judges, which is evidently what the North Carolina legislature wants to do, there's a great deal of politics involved in cultivating the favor of some legislator who holds the decision-making power over who's going to be a judge. In those states where there's a commission that has everybody from the dog catchers union represented on this big board that's going to decide who the judges are going to be, whether it's usually they're made up of a representative from the bar, a representative from the trial lawyers, a representative from the DAs, a representative from the defense lawyers, and then a few from the general public. Well, then the politics is lobbying the board. Try to, the board is going to come up, you put your resume in with everybody else, but then you try to lobby the board to get their blessing.
So how do you get the politics out of it? Is that possible?
It's not possible.
You can't.
So I don't think that tampering with the system of appointments so that the governor can't name someone to the vacancy is important enough to overturn the whole system.
Tell me about it, kind of, and again, I'm just going to ask here and then the kids on the other side of it, but take it where you will.
Well, I will try to spell it out for you as to what I think the legislature's long-term plan is. First of all, to make the judiciary as uncomfortable as possible until they endorse the legislature's long-term plan. And the long-term plan is for the legislature to be able to control who the judges are going to be, either through a commission which they create and staff and man, or directly to the legislature. I don't think the procedure there has been worked out, but the goal is to have judges who have to have the legislature's beholden to get a term on the court, and your second term would be determined by the same group, and they would be voting on whether or not they thought you had done a good enough job on their behalf to earn a second term. So they would basically control your ability to achieve a retirement.
It's a very politicalized thinking. Is it going too far? Do you really?
Well, that is way too far in my view, because this takes us back to colonial days and what was perceived as the travesties committed by the king against the royal judges. The royal judges would have their pay reduced, they would be kicked off the bench, they would be transferred to distant locations if they didn't rule in favor of the crown. And so that was embodied in the U.S. Constitution and most of the state constitutions to create separation of powers and a certain amount of judicial independence. Now, within the states itself, very few copied the federal method of ensuring judicial independence by having lifetime appointments, but most of them had lengthy appointments of 8, 10, 12 years for judges, because they wanted judges to feel like that they didn't have to look over their shoulder and worry about their last bad ruling that angered someone.
Right. What do you think of that?
Well, I think it's foolish, because the law hadn't gone into effect that they're trying to get the power under the amendment. So who is going to appoint the successor to the impeached justice? The governor. Who is he going to put back? He's going to put back the same people who were just impeached, and we can do this as many times as they want.
So that wouldn't make sense in your view?
No, it doesn't make any sense to impeach a justice because he voted in a way that you find offensive. They don't understand that all the fault really lies on Jones Street for restricting the access to the emergency judges. That was just one example of a pernicious step that the legislature took. I don't know why they took that. It can't be about money because the amount of money is so low. Therefore, you have to look for another motive. Since North Carolina became a state, the governor has always appointed vacancies. These vacancies have to be filled in a quick manner to carry on the public business, and it's much more cumbersome to go through the legislature. And since the governor has to execute the laws, then he should be the one to make those appointments. In many instances, particularly the judicial ones, they're temporary until the next election. So it's only going to be him putting somebody in for a year or so before there's going to be an election, and the people will decide who's going to hold that seat. But in the meantime, the work goes on. We don't have a protracted battle in the legislature over which candidate should go forward. Factions can develop. The governor's going to sort that out. If there's 2 or 3 applicants for a job, a series of interviews, and that selection is going to be made.
How does that matriculate down to your average person, though, right? How does it fall down the ladder and hit the rest of us on the head? You understand?
By pointing out that it will cause a delay, and it's going to, if you have a case pending in court or any of your friends or neighbors have cases pending in court, there will be a delay in their case until this vacancy is filled. And the vacancy can be best filled by letting the governor make that appointment on a quick basis. I think there's been an attempt to bring to heel the judiciary. For instance, the judges were the only state employees that didn't receive a pay raise the last time around. That's a pretty pointed message. We're not going to pay you any more, judges. They can't reduce our pay because that's built into the Constitution after the royal judges had that happen to them. So but they certainly don't have to give you an increase in pay when they're increasing the pay for everybody else, including the guy who's driving a dump truck for DOT.
So they are saying to you very pointedly, we're not happy with you, you're not getting a raise.
Yep, and I think that's the way it's interpreted. Certainly as a sitting judge, when we were denied pay raises and everybody else was getting them, I felt that that was a message aimed at me or my colleagues.
And what were they telling you?
I think they're telling us that we don't like the way you're doing business. And I'm not sure exactly, in some instances, why that was the case. We have a series of cases that are heard at our court under an expedited rule called Rule 3.1. When they transferred those cases, they transferred the, quote, Rule 3.1 cases are hereby transferred to the Supreme Court with a start date that's like December 2020.
So this is the legislature taking them out of the appeals court?
Out of the appeals court. The court that they say doesn't have enough work to justify existing at 15 is now having their caseload reduced by another 10% and those cases sent to the Supreme Court, which makes no sense. If a court doesn't have enough work to do, why transfer work away from it? Well, if you look at Rule 3.1 and what it does, Rule 3.1 sets up an expedited process at the Court of Appeals to get these cases in and out within 90 days. And these are termination of parental rights. These cases have been heard at the district court level, and the district court judge has agreed with DSS that these kids are living in harmful environments. Right. These are kids who are really down at the edges of society, and they need more help, but they're not getting it. The theory is that this increases the Supreme Court's caseload by producing statistical jump in the number of cases heard at the Supreme Court. And therefore, the Supreme Court must need a few more justices. And so they can create 2 new justices at the Supreme Court level and eradicate, if the governor or the legislature should flip or stay Republican, then they could control who those justices would be, and they would have control of the Supreme Court. That's the theory behind why they did it. But it's a pernicious thing to tamper with the court's jurisdiction, particularly when it deals with children who are in a dire situation and need to have their cases resolved as rapidly as possible. By sending it to the Supreme Court that's used to dealing with much larger issues, it bogs them down in legal minutia that they don't need to be involved in, and they don't have the staff resources nor the manpower to deal with it the way we do, and it's just going to slow that whole process down, and there's no reason to do that. I made the decision to retire because my loyalty, my first loyalty, comes to the people of North Carolina to whom I took an oath to do the best job I could, and to the court system, because I believe in the rule of law is important, and keeping the courts functioning and not being impaired is important, and more important than the party that I carry as my party label.
But some people might hear you say that and say if he really believes that being on the bench is the right thing for him and he can make the most difference there, he should have stayed on the bench as long as possible.
But I could only stay one other month, and at that point the court would be reduced in size, because I turned 72 in May of 2017, and the state statute says that judges must retire following the month they obtain their 72nd birthday. So I could only stayed one more month. By doing this the way I did, I ensured that the Court of Appeals stayed at 15 judges at least for the next couple of years. Now, next year there's going to be a Judge, Robert Hunter, who will turn 72 in, I think, April or May of 2019, and at that point the court will be reduced unless they fix this legislation.
They tried to come in and hammer you over the head with this thing, and you basically said, I'm not having it.
Well, they should have looked at my resume and seen that I was a former federal prosecutor and a colonel in the Marines. We don't back down from doing the right thing merely because of a party label.
Your party, you imply in saying that, was asking you to do the wrong thing. How do you feel about that?
Well, they weren't asking me to do anything. They were just assuming that I would go along with their plan, which was to reduce the size of the Court of Appeals. And they didn't ask me as to whether I'd go along with that. I'd done everything I could possibly do to get them to not do that, given them alternative legislation, had the Chief Justices write letters to every member of the legislature. Our own colleagues had tried to go to the Judiciary Committee and give them actual statistics showing that we're pretty busy as a court and we don't need to be impaired in the way they were going to do it. And in my career, not only on the bench, but living here in North Carolina, this is the first time I've seen a legislative body deliberately impair the court system. I'm not talking about appointing somebody you didn't like or doing anything of that nature with the court system, or not increasing the size of the court, or not increasing the number of judges that we have, but I'm talking about doing something that is going to slow the court down in its work, that's going to impair the ability to render justice on behalf of the people of North Carolina. And this is the first time that I've ever seen a legislature knowingly do that. I've never seen that happen before. So this is the only way that I knew how to respond to it. It's a real small step that I took. It only affects one seat on the Court of Appeals, but I know that that means 120 cases a year will be heard in the right time frame. When I retired, shortly after that, I went in front of the Executive Committee of the Republican Party for this county, because I have to live here and I see these people day to day. And I explained what had happened and why I had done what I did and who my loyalty lies with. And one old fella from down east said, "Well, son, when I first heard what you'd done, I thought you'd done wrong. But now I heard from you, the other side of the story, I'm right proud of you." And so I think that when people hear my story, they're proud of me for what I've done, and it's going to turn them against these proposed changes. At least that would be my hope.
But we can't vote for you.
No, but you can vote against some of the proposals that are coming out because they're asking for voter support. If those amendments get on the ballot, you can vote against those amendments.